Judge rules either way, free choice or discipline, regimentation. How should we look at it? We'll tell you more on that big Supreme Court verdict, including lawyers who argued in the case will join us tonight. But first, as always, it's time for the 9 headlines at 9. The Supreme Court delivers a split verdict in the hijab case. Justice Gupta bats for a ban. Justice Dhulia for freedom of choice. Case now referred to a larger bench. Ban on headscarves will continue in the meanwhile in Karnataka institutes. Aam Aadmi Party's Gujarat chief is released hours after being detained in Delhi by the police. Alleges misbehavior by the National Commission for Women chief. Kejriwal calls Gopal Italia's detention an insult to Gujarat's Patel community. All this taking place ahead of Gujarat elections in December. More public warring over the Congress presidential election. Shashi Tharoor now alleges differential treatment being meted out to him within the party. This a day after Kharge plays down his competitor. Tharoor says there's no level playing field. Prime Minister Modi in pole-bound Himachal Pradesh inaugurates a slew of development projects including IIT Una and 2 hydropower projects. Dates of the election likely next week. Enforcement Directorate files a charge sheet against Rana Ayub in a money laundering case. The agency claims Rana set up charities with the intent to cheat people, receive foreign funds. The journalist claims this is an attempt to silence her because she's a critic of the government. Kerala's holy city, Patnam Thitta, occult shame after cannibalism horror. Now a case of black magic on children emerges. Locals stage a massive protest. IMF lauds India's economic growth and digital cash transfer scheme. Claims India is the one bright spot on an otherwise dark horizon. This comes a day after inflation figures had reached a 5-month high. Sourav Ganguly makes his exit from the BCCI. Official says he's ready to move on to bigger things. And after incessant rains lash Assam, the state battles a third wave of floods in this year. 70,000 people affected. But tonight's top story comes from the Supreme Court, where it seems that the showdown over the hijab, whether a hijab can be worn in schools, is far from over. A 2-judge Supreme Court bench gave a split verdict today on the Karnataka campus ban on the hijab. While Justice Hemant Gupta ruled in favor of a ban, Justice Sudhanshu Dhulia struck down the ban. The petitions against the hijab ban will now be heard by a larger bench of the Supreme Court. What happened in the court is our top story tonight.
After 10 months of tumult and face-off, which ignited passion and legal fight, the hijab stalemate is here to stay. The 2-judge Supreme Court bench has delivered a split verdict on if campuses can allow Islamic hijab over prescribed uniform. Justice Sudhanshu Dhulia set aside the Karnataka High Court judgment and quashed the Karnataka government's hijab ban order on February 5. He held that the entire concept of essential religious practice was not apt for the dispute. Justice Dhulia added that only education of girl child matters. Justice Hemant Gupta, on the other hand, upheld the Karnataka High Court verdict, which approved Karnataka government's campus hijab ban. Justice Gupta also raised 11 critical questions on the issues of essential religious practice, rights of students, and the government.
While Justice Hemant Gupta, in his analysis, has gone into all issues including essential religious practice and the right of the government to formulate rules, Justice Sudhanshu Dhulia has said that this is not about essential religious practice. It is about the freedom of expression and freedom of choice of religion. And effectively, it is also about education of girls, particularly in poorer rural areas.
With no stay by the top court on the Karnataka High Court judgment and the Supreme Court being split, the High Court endorsed ban on hijab in campuses with uniform will continue.
The 26 petitions that have been filed before the Supreme Court challenging the Karnataka High Court order, which had imposed the ban, will now be placed before the Chief Justice of India so that the matter can be referred to an appropriate three-judge bench. The three-judge bench is likely to decide on two key aspects. Number one, as to whether or not a ban on hijabs in educational institutions should be allowed to continue in Karnataka as is the case now. And number two, whether this is a case that is fit to be referred to a 9-judge constitution bench to determine whether wearing of hijab is essential to the religious practices of Islam.
As the battle shifts to a larger bench, a longer legal war may be on the cards. With Anisha Mathur and Nalini Sharma in Delhi, Bureau Report, India Today.
So is this ban a violation of fundamental rights, free choice, or has discipline been imposed? Is a uniform essential to equality? Is the hijab really an essential religious practice for Islam? Does the ban hit the right to education? These were all questions that were raised in the court. What were the responses? We'll go to those one by one. But joining me, therefore, on the show tonight are people who've closely tracked this case. K.V. Dhananjay is a senior advocate, from Karnataka, and is someone who had raised this issue in its original form when the ban was imposed by the Karnataka government. I'm also joined by Vivek Subba Reddy, Senior Advocate, High Court of Karnataka. He's also President, Advocates Association of Bengaluru. And by Dushyant, who appeared for the petitioners, Senior Advocate, Supreme Court, appeared for the petitioners. So Dushyant, let's come to you first. Since you argued in the court and we've seen a clear split verdict, Justice Gupta is very clear that a hijab is a reasonable restriction that a school can put because a school has the right to impose a sense of uniformity, and secularism, he says, does not mean that any religion is given any preferential treatment when it comes to a dress code. On the other hand, Justice Dhulia believes very differently that right to religion under Article 25, right to freedom under Article 19 allows people to wear the dress they choose to. How do you see two such contrasting views from two judges, Mr. Dave?
Well, it's not so easy an answer, but I can definitely say one thing with greatest respect to Justice Gupta, whom I really admire, that he is completely wrong. I don't think he has understood the Constitution. I don't think he understands the scope and ambit of the freedom of religion that the constitutional framers, provided in our Constitution. I, in fact, cited the Constitutional Assembly debates, which before the bench. And throughout the debates, the members after members of the Constitution Assembly, including T.T. Krishnamachari, Kanayalan Munshi, and Santhanam, many others, repeatedly said that Article 25, which was old Article 29, Article 19, is an article of toleration. And they said that we must therefore allow every kind of a belief by any religion, and not just a belief, but the conscience of the people who profess the religion and the practices which are followed by them. Now, that's precisely what the Supreme Court's 7-judge bench has earlier said in Shirur Math's case, that these are all expressly protected. Therefore, I don't think that Justice Gupta's view is at all in consonance with the Constitution, in consonance with the previous judgments of the Supreme Court. And I think I would much rather say that Justice Dhulia has taken an eminently just and legal approach, and I commend that for acceptance before the nation.
No, you're emphasizing Article 25, freedom to practice your religion and hold religious beliefs. However, Justice Gupta has said, and I quote here, government order, that's the Karnataka government order, promotes uniformity, encourages a secular environment, order in tune with the right guaranteed under Article 14 of the Constitution. Therefore, he claims that the right to equality is strengthened if you have a uniform dress code, and it is a reasonable restriction on Article 19 as well. That's so, there are two different, while you say that Justice Gupta has got it wrong, his proponents would well argue that he too is following a constitutional principle.
No, I don't think I can agree to that view of Justice Gupta for the simple reason that right to equality does not take away freedom of religion. Freedom, every article, of the Constitution, the fundamental articles spring into being all the time. And therefore, you can't say that one article is at the cost of another article. Certainly not. So, giving that into, play, I personally feel that freedom of religion does not stop at the school gate. The freedom of religion, in fact, continues for every child who is studying in a school. And as I had told judges, that look, nobody is saying that there should be no uniform. The color of the hijab was also the color of the uniform of the colleges. And therefore, these are not, this is not military you are dealing with. This is schools where, every child must have a right to express his or her freedom. And if you try to curtail that by saying that, we have a right to put some kind of a restriction in the garb of equality, I don't think equality principle can be evoked to the extent that they have done. Okay. So I honestly feel that Justice Gupta has gone terribly wrong in the view that he has taken.
Let me bring in Mr. Reddy, because Mr. Reddy opposed what you're saying and he supported what the Karnataka government does. Mr. Reddy, how do you respond to what Mr. Dave is saying? That he seems to give primacy to Article 25, as it would seem Justice Dhulia did, freedom to practice your religion. Therefore, if I choose to wear a hijab, that is my right under Article 25. It does not interfere with someone else's rights also. By wearing a hijab, I'm not interfering with someone else's rights, and therefore I must be entitled to wear one. Your response to what you heard, which in a way Justice Dhulia was challenging what the Karnataka High Court said.
Yes, Rajdeep, I think there are two perspectives to this. First of all, what happens within the campus is to be controlled by the government. The government has a stake in ensuring uniformity within the campus, in ensuring that religion does not become a symbol of invasion or a symbol of influence within campuses.
Right.
I think this is an essential issue which the state, in which the state has the stake, and the state has to regulate. And it is from this perspective that Justice Hemant Gupta said that there must be equality of uniforms within the campus. And he is absolutely right, because throughout the length and breadth of this country, Supreme Court lays down the law for the country. Throughout the length and breadth of the country, we have issues as to what should be the uniforms in campuses. So it is not the religion that prescribes the uniform in the campuses. It is the government that prescribes what should be the uniforms. Therefore, the government is absolutely right. The government has traced its powers to the right sections while drafting these orders. This is number one. Second thing is, coming to Mr. Dushyant Dave's argument regarding right of conscience and freedom of religion, freedom of conscience and religion. I think here the essential religious practice question comes as to whether it is freedom of conscience per se or an essential religious practice which reflects the core belief of a religion. And whether that core belief of that religion has to find reflection through the wearing of hijab or through talaq or through various other things. And on this question, Justice Hemant Gupta has come out very clearly and said that it is not an essential religious practice and therefore it does not attract Article 25. I think this is where Justice Dhulia, Sudhanshu Dhulia, has completely missed the point. The Karnataka High Court, with the three judges, a full bench of the Karnataka High Court held, including a learned judge, Justice Kazi, held that it is not an essential religious practice. And that view is reflected in the views of Justice Hemant Gupta. And this is where Justice Sudhanshu Dhulia wholly missed the point. And I think he is wrong on the perspective of law, because even in Talaq case, it was held that it is not an essential religious practice, something which reflects the core belief of a religion.
So you're saying
Article essence of a religion.
Sure. So you're saying Article 25, this was debated in the court, whether it is limited to what constitutes essential religious practices. Mr. Dhananjay, interestingly, one of the arguments that was made even in the Karnataka High Court by the government of the day, saying many of these schools did not make hijab. The girls in many of these schools did not wear hijab till a couple of years ago. So if it was an essential religious practice, why were they not wearing it all these years? Suddenly they wear it and a ban is imposed, and when the ban is imposed, then the petitioners argue, no, it's an essential religious practice. The argument they are making is it is not an essential religious practice. Therefore, for example, it can't be compared with a kada, which Sikhs claim is an essential part of their religious belief system. Is that argument settled now, or do you believe that is one of the core arguments that will now go to a wider bench?
Well, it was unnecessary for the girls to show or to prove that they were wearing hijab much prior to that, because the right to wear a hijab doesn't really depend on having worn hijab in the past year or 10 years or so. So that is not how the law would have, that's not what the law would have expected. So neither was the government able to show or prove that they were not able to wear a hijab, because that question, answering that question would have made no difference whatsoever to the eventual outcome. The government of Karnataka came out with this order, and the touchstone of that order was courts have spoken according to the government, and courts have unanimously said that wearing of a hijab, can be curtailed in educational institutions. Once said that the hijab ban would have the effect of increasing Muslim girl students' attendance in school. So their touchstone was that there is judicial unanimity, and that attitude obviously takes a huge setback today, because the Supreme Court has spoken. An eminent judge of the Supreme Court has said that this policy of the government is illegal, is unconstitutional. And should you read Honorable Justice Sudhanshu Dhulia's judgment, you will find that the judge has asked very simple questions that a common person can that will easily resonate with the common person. The questions that the judge went on to ask is, who is in any way harmed should a girl wear a hijab? And then the judge goes on to ask, what happens when we see that girls have, a few girls have stopped attending schools and few girls have even missed out their examination? And is that not a matter of greater concern than other constitutional issues and religious issues and legal issues?
No, but those are practical. No, those are practical questions, Mr. Dhananjay. Those are not constitutional questions. Those constitutional questions will eventually have to be answered as well. Whether this constitutes an essential religious practice or not is a question that is still blowing in the wind. There are Islamic countries in the world that do not impose, that do not make hijab mandatory. So why should...
Well, I think the way to look at it is this. The government has vast powers under the Karnataka Education Act. If the government tomorrow decides, and the Education Act very clearly says that the government will set the syllabus and prescribe textbooks. If the government tomorrow says that they don't want to include the 1905 Bengal partition in its history books, and somebody who questions that in courts, it's possible that all the courts in the country might say that the government has given the prerogative to decide on syllabus in history textbooks, and the government has decided what it has decided. We would not interfere. So the fact that courts would uphold the government's powers does not in any manner tell you what the government did is good educational policy. There is nobody within the government of Karnataka, there is no officer within the Department of Education who would come forward and say that this uniform rule that we have brought in, which bans hijab, is a rule that is worth it, even if it would lead to some girl students missing out on school or on education. And that is why I've always been pointing out that a circular being debated in the High Court and in the Supreme Court for weeks or months just does not make any sense when you consider how other similar democracies deal with it. There has to be a statute. If you wish to ban something, if you wish to take away somebody's right, you just can't do that through a circular. The Karnataka Education Act does not even answer a simple question like what would a private school do when a parent does not pay the fee of the child. And courts have said, look, this statute does not talk of expulsion. This statute does not talk of suspension. So if you're a private school and if a parent refuses to pay the fee, please don't terminate the child. Rather, file a suit against the parent to recover the fee and continue the child in school.
Rajdeep,
this is the Karnataka Education Act.
I think Dhananjay misses the point here.
Yeah, go ahead, Mr.
Point here.
Yet, Mr. Reddy.
Just a short intervention. While making this law or while drafting this circular, government had a policy behind it. It is not Dhananjay's personal perception to replace that policy. But of course, we are all testing the constitutionality of this
No,
policy.
what was the policy?
The
What
policy from
what
2013
according to
has
you
been-
drove this policy of the Karnataka government in the first instance?
The government has not broken any policy. It has been the consistent policy of the government since 2013, when it was prescribed, that there has to be uniformity there has to be equality in uniforms. There has to be sameness in uniforms. So this was done through a very clear structure. There was a school committee, and the school committee was headed by the local MLA, and it had been drafted by this committee. It was not the government's personal policy. And this had been in vogue since a long period of time.
Can I?
And if Dhananjay has a personal perspective about it, so be it.
Okay,
But this is a policy regarding uniforms.
You're saying uniformity of dress code was part of the Karnataka government's policy since 2013. There is also the question that the court in a way wrestled with these two judges, freedom of choice, Dushyant Dave. You know, you've got Justice Dhulia saying freedom of choice. Each individual has the right, he or she, to decide what she wants to wear. But that's a very dangerous argument, because there will be others who will say your parents are coercing you into wearing a hijab. So where is the real freedom of choice for an 8, 9, 10-year-old girl? Now this question also seems to be approached very differently by Justice Gupta, who is very clear that it's the school that decides and not the parent. Do you believe that this too will have to be settled by a wider bench, the notion of freedom of choice?
I must tell you something shocking. Both Justice Gupta and my dear friend Vivek Reddy have completely lost sight of the fact that the very government of Karnataka had issued a circular for the academic year 2022-23, expressly providing that uniform is not compulsory, and anybody insisting on wearing of uniform in colleges will be penalized. This circular was placed by me before the bench. The judges were shocked. They asked the government to respond. The government failed to respond. So that's the first thing. Secondly, Vivek is rightly saying essential practice. Essential practice argument was rejected by Constitution Bench in 1954. In Shirurmat, Justice Mukherjee speaking for the court said, and I'll read one line, Learned Attorney General lays stress upon clause 2A of the article, and his contention is that all secular activities which may be associated with religion but do not really constitute an essential part of it are amenable to state regulation. Now, judges respond to that. The contention formulated in such broad terms cannot, we think, be supported. Now, this is what Supreme Court said in 1954. Supreme Court says very rightly that matter of religion is a matter of personal belief, personal conscience. We are not talking about anybody forcing here. It is a voluntary act of a child to wear a hijab, like a Sikh child would wear a turban. Constitution doesn't protect a turban. It only protects kirpan, because otherwise arms are banned. So you may have a tilak, you may have a Mangal Sutra, you may have a Rakhi, as I have. Every one of these is a religious symbol. In fact, recently I read somewhere that Karnataka government has said that students in school should come with a Gita in the school. What is this? See, this is nothing, Rajdeep, but marginalizing the minority community and to create an atmosphere of hatred in this country so that the Hindu votes are consolidated and BJP benefit. Sadly, there is no other purpose. There was no policy till this year. Why is it that for 75 years, BJP has been in power earlier? Why is it that it never thought of it earlier?
Vivek,
So it is only when elections are round the corner.
I'm sure that
Just a sec, Vivek, I didn't interrupt you.
Mr. Dave,
No,
Mr.
Mr.
Dave,
Dave, you had your word. Let him respond.
Just when the elections are round, the corner, BJP thinks this as it is doing in Gujarat, in Garbas, or now it is doing here in Karnataka. Nothing else.
Okay. Mr. Dave, you made your point. Yes, Mr. Reddy, respond to that. That there is a political angle to it.
I like the way Mr. Dave is escaping the moot question on essential religious practice. See, Shirur Mutt's case, which Mr. Dave pointed out, and I was listening to it, I think these are general brushes adumbrating the concept of what is an essential practice. But Mr. Dave must realize that in Hanif Qureshi's case, a similar constitution bench judgment in 60s, where the issue came up as to whether cow slaughter or eating of beef was a way of life, was an essential religious practice. The Supreme Court turned down this question and said it is not an essential religious practice. A similar question came up in the Talaq judgment, where Justice Nariman said that Talaq is not an essential religious practice. Well, merely because in 1950s something was stated in Shirur Math's case does not prevent the Supreme Court in testing the core beliefs, the fundamental beliefs of a religion as to whether it is an essential religious practice. Sir. And the Supreme Court has tested it time and again. And these are not political questions, Mr. Dave. These are essential constitutional questions which are being debated in the court. And what the state has in stake is that it has to ensure campus uniformity. Mr. Dave may personally not like it. Well, that's his problem. But campus uniformity is something in which the state has a stake. The state government has a stake. Because it has to ensure in all secular countries, we ensure that the campuses are kept away from invasion of religion. Well, the state has a stake in that. Okay. And I'm sure that if it is not an essential religious practice, it is all the more clear that it should not come into this. So the moot question is, Mr. Dave, why did it suddenly crop up in 2021? Where was it lingering all these years? Unless and until there has been an attempt from some quarters to infuse this mischief for which Mr. Dave is arguing in the campus. That's what specifically put forth in Kundapur and in Udupi. And that is what the courts have taken judicial notice of.
Let Mr. Dhananjay respond to that. Vivek, let Mr. Dhananjay respond to that. There are two views of looking at it. Suddenly in 2021, you have women girls who are not wearing hijab, coming to schools wearing hijab. So there are those who will argue that Islamist organizations like the Popular Front, its campus front, were pushing young girls to wear hijab. That this was not out of free choice. They were also making a political statement.
Well, I am also the legal counsel of the largest body of private schools and colleges in Karnataka. Its name is KUSMA, Karnataka Unaided Schools Management Association. I'm the legal counsel. I've been the legal counsel for the last 12 years. And I can tell you that in private schools and in government schools and colleges, hijab was being worn. And we have more exposure to the Karnataka Education Act than any advocate within the government. So it is with that sense of responsibility, I would like to point out that hijab was always being worn in some schools, some colleges, and nobody should be disputing that. Now, we will come to the other issue, which is the government kept on saying that it was forced to take this view because in some schools and colleges, children started wearing saffron shawls. Now, it's very surprising that neither did the High Court of Karnataka nor even the Supreme Court asked the genuineness of that movement. Did anyone go to the High Court of Karnataka or to the Supreme Court to say that the order passed by the schools and colleges had the effect not merely of prohibiting hijab, but also prohibiting saffron shawls? Did anyone go to the court to say that this prohibition of saffron shawl would hurt their religious belief or anything? Nobody went. And that largely, if you go by common sense principle, would tell you that this was more like something that was staged. And it's unfortunate that the High Court of Karnataka and also the Supreme Court did not stress on that aspect. They ought to have asked pointed questions to the government and said, you were citing the saffron shawl as a disruption for which you had to come out with a hijab ban. How is it that people who wanted to wear saffron shawls and who are no longer permitted to wear don't come to the court to agitate it?
This is not an answer to the sudden manner in which hijab came in. This is not an answer, Mr. Dhananjay, to the sudden manner as to why hijab issue came to the forefront only in Udupi and Kundapur. Not
by the way, in private schools and college, and this uniform concept, by the way, Rajdeep, the richest schools.
Saffron shawl.
Let Dhananjay, yes, Dhananjay.
Rajdeep, the richest schools, by the way, in Bangalore, which charge upward of 5 lakhs for nursery and Montessori, they don't have a concept of a uniform at all. The concept of uniform never populated the discussion around the Education Act in the last 75 years. I want to tell you that.
Let's leave it there. As we've seen, these are contentious issues, not settled fully by the court yet. The interesting thing, Mr. Dave, Mr. Reddy and Mr. Dhananjay, is that the court will now, this will go to a larger constitutional bench where issues like essential religious practice or not will have to be clarified, which has not really been fully clarified by the two judges, particularly Justice Dhulia, who's focused more on girl-child education and the need not to provide the girl-child unimpeded education. But I appreciate having three fine lawyers joining me to tell us in a way where they stand. Yes, Mr. Dave, you want a final point? Yes.
Yes, I want to say one thing, especially to my friend Vivek, that Karnataka in recent times has a history of targeting the minority community. This is part of that. Take, for example, the Idgah ground in Bangalore, where suddenly after some 200 years or 400 years, they wanted to allow, Ganpati Visarjan or Ganpati Pujas there, which was exclusively held by the Muslim community. Take, for example, Mr. Reddy, don't interrupt. Please. I don't interrupt you.
Okay, then, Vivek, I'll let you respond to it. Vivek, I'll let you respond. Let me finish.
This is BJP. BJP wants to stop everybody from talking.
No, Vivek, you're being unfair.
There is no necessity.
I respect you. I showed you respect.
Mr. Dave,
show some respect.
This is a friendly chat. No need to get tense on national TV.
Okay, Vivek, I will let you respond.
Horrible habit you have.
Vivek, yes.
You can't tolerate
Mr. Dave, make your point.
Independent view.
Mr. Dave, make your point.
Yes. Take, for example, in recent times, Muslims selling, flowers and, other things in temples were disallowed from selling it. Karnataka is somehow doing this, deliberately to target. Rajdeep, 5,000 years of history of liberalism this country has. It doesn't need this. Let any child wear whatever it wants to. Why not? Do you have the courage to stop a Sikh child from wearing a turban? You don't have the courage because you have seen the militancy of the Sikhs.
Okay,
don't force the minority community to militancy.
Okay.
You may say that I don't agree with you.
That can't be a reasoning in a court of law, though.
You, that PFI has encouraged it. You are pushing young Muslim men and women towards radicalism by this kind of action.
Okay, Mr. Dave, you made your point. Yes, Mr. Reddy, now you can respond. Dushyant, you made your point. Yes, Mr. Reddy, now you can respond.
Mr. Dave, I'm sorry for having interrupted you. Anyway, the issue is this. The point is that you talk about liberalism. There was an existing school policy. Mr. Dave has to answer in this
no policy, Mr. Reddy.
Now you're intervening with him, Mr.
Dave. Please answer a fundamental question as to why some children came in front of campuses asking for hijab, which was not there all these years. Who instigated this?
I went to a school as a child in Palanpur in 1960.
The government was responsible for all this. Please know the facts.
Okay, we are now...
Please know the facts. These are basic facts.
Okay, I'm going to leave it there. As I said, these are constitutional questions that will also have to be addressed. We dipped into the politics just now, and that's where I'm going to turn in a moment. But I appreciate my three guests joining me today. Because this is such a major issue, we believe, we are also going to look at the political angle. Because the reaction to the Supreme Court verdict in Karnataka is on expected lines. The BJP government in the state says the hijab ban will continue. The petitioners are hoping that the court will lift the ban soon. Take a look.
The Supreme Court's split verdict on Karnataka's campus hijab ban has left all parties disappointed. The Basavaraj Bommai government has made it clear the campus ban upheld by the Karnataka High Court will remain in force. Karnataka Education Minister B.C. Nagesh trained guns on the Congress, accusing it of egging on the Muslim community to fight the hijab ban.
Congress always fight elections not on the development issues or the people issues. They always want to fight on emotional issues, particularly as one particular religion is most emotional. They want to concentrate on that votes, and they have done not now, since 1947 up to today.
The opposition leaders, on the other hand, stepped up their attack on the government.
Why did the government ban it? And they banned it under the pressure of the Hindutva groups because they wanted to come with a saffron shawl and communalize the issue, make it into a communal issue. It was never a communal issue. It was an issue where a Muslim girl was encouraged to come to educational institution.
With colleges shut for the Dussehra break, there was no activity on the campuses where students had protested, demanding their right to wear hijab. The petitioners are hopeful their view will prevail when a larger bench of the Supreme Court takes up their appeal.
जस्टिस दुलिया ने जो अपील्स थे उसको अपहोल्ड करके यहाँ के गवर्नमेंट ऑर्डर को रिजेक्ट किया है। हेमंत गुप्ता सर ने उसको अपील को रिजेक्ट करते हुए कुछ हमने 11 क्वेश्चंस था उसको सब अपील्स के हमने आंसर दिया है, इतना ही बताया, लेकिन और कॉन्स्टिट्यूशनल कुछ रेफरेंस इन्होंने नहीं दिया। इस वजह से हमें उम्मीद है कि यहाँ पर अभी चीफ जस्टिस ऑफ इंडिया के सामने हमारे जो बच्चे जो अपील डाले हैं वो गया है। हमें आशा है कि डेफिनेटली वो हमारे फेवर में, यहाँ के संविधान के फेवर में वो डिसीजन देंगे।
With no clear verdict on hijab ban, the issue will stay alive in the build-up to state elections next year. Bureau Report, India Today.
Joining me now are 3 women and a man. Irfa Jan is a spokesperson in National Conference, but she has a strong view on this. She comes from Jammu and Kashmir. Zakia Soman is women rights activist, co-founder Bharatiya Muslim Mahila Andolan, and she was among those who had stood up on the triple talaq issue. Yashpal Suvarna is vice president in Udupi College, and Farheen is an IT consultant in Bengaluru. I'm going to get each of them to react to what they've heard legally and politically. Why don't I start with you, Farheen, because you are a young IT consultant there in Bengaluru. You tell us, as a young Muslim woman, how do you see this verdict playing out? What, according to you, is the right way forward? Do you believe you're wearing a hijab? Should Muslim women be given that freedom of choice? Should an 8-year-old, 9-year-old girl, does she really have choice over it, or does her family impose it on her?
Absolutely. I think this is a matter of choice for every single child or woman. And I think it should be left to them to decide whether or not they choose to wear that hijab.
But does an 8-year-old have a choice, ma'am? Does an 8-year-old have a choice? This issue is being raised in Iran as well in a very different context, that actually society is not even giving women the real choice, especially young women.
Well, that is a misconception in my thinking, because it's not something that has been forced on anybody. I'm going back to my own case. I've grown up, born, raised in Bangalore, and never worn a hijab till I realized that the hijab is a part of my identity. My religion asks or expects of me to wear it, and I think I'm perfectly comfortable wearing it. And I think this right should be given to every single woman who should be able to make that choice.
But Farheen, sorry to intervene. A decade ago, many women didn't wear it. So what changed suddenly?
I was one of those women who didn't wear it a decade ago. But awareness, coming to understand what is expected of me, and then making a conscious decision is something that everybody should be allowed to do. If we're allowed to take up whatever course or whatever career we want to go into, then we should also be allowed to dress in a way that is humble. We're not being flashy, we're not being distractive, we're not taking ourselves away from the main education platform. We're not doing something that is going to make people feel like there's someone out of place in that institution. We're only being humble, we're only being simple, we're only covering up. We're not exposing, on the other hand.
You don't see it as the rise of conservatism, the rise of radical ideas that are forcing women like you, who earlier were not wearing hijab, to wear it today?
I don't think so. No. For me, it was never a forced decision. It was a conscious decision. And I think most women now are doing it not because they probably had that back of their mind, that we're going to do it one day. Now that those emotions are coming to the surface and they feel like now's the time. Now I have to show that I'm going to exercise my right, and I'm going to do what I think is best for me.
Irfa Jan is joining me from Jammu and Kashmir. Irfa, what's your view? Do you believe a woman really has that choice today in Islamic societies, even in this country? Or, go ahead.
Well, Mr. Rajdeep Sardesai, I am a Muslim woman sitting right here in front of you and not wearing a hijab. So I guess we do have the choice. And for one millionth time, Muslim women do not need saviors. We do not need men and people coming from all sides of the society and saying, we want to save you. Instead, we need saviors like the kind of Mr. Dhulia, who will ease our access to educational institutions like he did. It's actually quite ironical that people who on one hand pretend to save Muslim women from patriarchy also happen to be the same women who would want more and more restrictions on the right of Muslim women to clothe themselves when they access educational institutions. It also happens to be the same people who would rather want us out of those educational institutions and say, listen, we are throwing you out of the educational institution because we want to save you.
No, they are calling for uniformity. Irfa, they are calling what the Justice Gupta argument is uniformity. That if other school, that no special provisions can be made for any religion when it comes to dress code.
You see, when it comes to uniformity, we cannot have a kind of uniformity that does not take into account diversity. For example, I cannot open a school and make beef curry the lunch menu, because I will have to take into consideration the fact that people of all religious, beef curry or pork curry, for example, because I will have to take into consideration that people of all religious different religious communities are going to be attending my school. If we look at uniformity, we have seen schools in the UK, schools in the United States of America make reasonable accommodations for Hindus, for Sikhs, for Muslims by allowing headscarves and turbans to be a part of the uniform. Reasonable accommodation is a perfectly acceptable way, and it's a perfectly acceptable thing in a uniformity. It does not, in fact, it brings more diversity into uniformity. As Mr. Dhulia
very interestingly, you used the word reasonable accommodation. Justice Gupta used, of course, reasonable restriction as he saw what the Karnataka schools were doing. But Zakia Soman, can this fit in with your, when you stood up against triple talaq? Many saw triple talaq as being essentially patriarchal, essentially being anti-woman, therefore it had to go. Does the same rule apply to hijab in your view? You're not wearing a hijab, neither is Irfa.
Yeah, so I think here the situation is somewhat different, and the girls are caught between the crossfires of patriarchy masquerading as religion on the one hand, and the insidious politics of religious polarization on the other. And what we are playing with here is the future of the girls. Right to education is a fundamental right, as is right to privacy and right to freedom of expression. But on the one hand, the parents will not allow the girls to go to school without hijab, and the schools will deny them entry into the classroom precisely because of the hijab. So I think here the parents, the society, the community, the education institution, even those sitting in power, everybody is being unfair to the girls. Reform in the Muslim community, equality and justice for Muslim women is a very serious issue. It cannot be brought about top down. It cannot be bludgeoned through these kind of blows. It's a time-consuming, organic kind of a process. And for a girl to realize and understand that she never had a choice, that hijab is a patriarchal imposition. For a girl to understand that, she has to undergo the journey of education, of empowerment.
Do you see it as a ma'am, do you see it as a patriarchal imposition?
It is a patriarchal imposition, doubtless.
Okay.
It is not mandatory in Islam. It is a patriarchal imposition. It is a regressive practice, and I am 200% against it.
Okay.
But when the girl says that it is her choice, for her to understand that she really has no choice, she is conditioned by social pressure, to understand that she needs to undergo the education journey, which has now been halted because of this ill kind of a move.
Okay, let me bring in Yashpal. Let me bring in Yashpal Suvarna from Udupi College. Are you going to, do you believe that you are going to, how do you see this judgment now playing out on the ground? Will colleges like yours continue to say that if a girl comes with a hijab, we will not admit her? Is that part of your admission policy, Mr. Suvarna? You're on mute. Is that part of your admission policy, Mr. Suvarna? You've got to unmute your mic and then speak, sir. Unmuted. Unfortunately, we are not being able to get through to Mr. Suvarna because remember, we would have liked. Can you hear me now?
Yeah.
Yeah, you tell us. Are you going to make it mandatory? Continue to make it mandatory for admission to wear a hijab?
Yeah, from the 2004, our college have framed the rules and regulations on to run a college in a disciplinary manner. There should not be discrimination. There should not be every student should be treated equal. From the year 2004, the same rules and regulations have been followed.
So are you saying from 2004 your college followed the rule that girls with hijab cannot enter college?
No. Till 2021 December, nothing in that college. After the 2021 December 31st, that 6 girls started creating issues. Their intention was to curb the future of the poor girls who are coming to that government college. That was their intention.
No, I want to understand from you, Mr. Suvarna, until 2021, you did not stop a girl from coming to college with a hijab. Am I correct or not?
No one student was wearing hijab to that college.
So you're saying
there was no issue in that college. Huh?
You're saying they started wearing the hijab only after December 2021?
21 December 31st, they started.
So today, if they come to college tomorrow with a hijab, will you stop them or will you not allow them?
No, the rules have been framed in that institution that each and every one student should be treated equally.
When were these rules framed? Which year?
From 2004 itself. You have produced the document.
Okay, you're saying, okay, that's important. You're claiming that the rules were framed in 2004 itself. Therefore, if these are the rules, in a way that colleges are setting, how do you see this, Irfa? If these are the rules, do the colleges' rules prevail or the girls' choice prevail? Irfa?
No, a college or institution.
This is a government college.
Yes.
As far as I can understand, this is a government college.
Yes, it is.
And a government college which is funded by the taxpayers. And essentially that means this government college rules cannot override the fundamental rights that the Constitution of India provides to each one of us. So the government college cannot make me do something through its rules which is against my dignity and which is against my chastity and which I consider to be chastity. Again, it's
but from 2004 to 2021, no woman wore according to them, the girls did not wear a hijab. They wore a hijab in December 2021.
You see,
this grew up, Rajdeep. They were young at that time. They became teenage girls and they started wearing it. So it's quite understandable that they started wearing it at a later stage in life.
Okay.
Typically.
Okay.
I think,
after all, it is a girls' college. Girls' college.
Okay. Yes, Irfa, very quickly, and then I'll come to you, Fareen, for a final comment. Yes, Irfa.
You see, I think when we constantly say, when did the girls start wearing it, we are constantly trying to probably bring out this conspiracy and give legitimacy to the PFI conspiracy, this radicalization conspiracy, that radicalization conspiracy. The question is, if tomorrow a fresh woman who enrolls herself into this college for the first time decides to wear a college, would the state protect her fundamental rights or not, or would it shut the doors on her?
You're saying it's about the fundamental rights that a girl has. Others will say, Fareen, when I enter a college which already has on its rules that hijab is prohibited, I am entering it of my own volition. I am accepting the rules of the college. The college has its rules framed and given to you in advance.
If these rules were framed ahead of time and people knew that they're entering this institution fully aware that they're not going to be able to practice their religion, then it's up to them what they do. But if this rule didn't exist, which it didn't exist in all these years in Karnataka, all of a sudden you tell us that now you either choose religion or your right to education, then I think that's absolutely not something that we should be able to accept easily. Education is a fundamental right. We all agree on that. So the way you're dressing up should not affect your right to education. Which educational institute you choose is really up to you. But how you dress should be left to the individual. It really does not make sense to go and tell them that you should take off the hijab if you want to be able to go to this particular institution. It does not.
So you're questioning the very rules. You're questioning the very rules that the college have set up. Zakia, you want a final word? Is there a middle ground that we can find, given these complex issues, far more nuanced? They are not black and white.
Yes, so uniform cannot be more important than education. The spirit of our constitution is about inclusion. It's about a compassionate view. And even the new education policy talks about including reaching out education to every marginalized child. And that would definitely involve the girl child. Okay. So I think we need to shed extreme views on all sides and keep the girls, their education and their future in mind. And with that in mind, we should, look at this whole matter.
Okay, we leave it there. The complexities of this issue is why perhaps we've had a split verdict. At a time when society is polarized and people will have strong views one way or the other, there is a middle ground that could be found. A middle ground that balances constitutional rights with, of course, schools and colleges and their demands and their restrictions. Can that be found without hurting religious sentiments? Can that be found while preserving secularism as we see it? Can that be found ensuring equality prevails over all else, while also ensuring diversity is celebrated? These are all complex questions that hopefully a wider Supreme Court Constitution bench will answer. And maybe that's what makes India such a fascinating country, that we have these divergent opinions and we can still discuss them in a democratic manner. I appreciate all my guests joining me on what has been our special focus on that big hijab verdict today in the Supreme Court. Let me leave you though with something very different, an image of the day. Army dog Zoom, who was being treated in Srinagar after suffering gunshot wounds while fighting terrorists in Anantnag in Jammu and Kashmir, passed away today. Despite injuries, Zoom had continued with his task, pouncing upon terrorists, resulting in the killing of 2 terrorists. Tonight, we remember Zoom. Good night. Goodbye. Stay well. Shubhratri.